Today, we've got a relatively unusual seminar in the sense that we don't have many legal scholars so far that have contributed towards the seminar. So it's great that we've got Yuval Feldman here. Thank you, Yuval, for agreeing to do this. The format's the same as always. Yuval will speak for about 20 minutes and then we'll throw it open to questions and comments from the floor. He's going to speak about reconciling law with and behavioral public policy. So without further ado, Yuval, I'll hand over to you.
Thank you, and thank you for everyone for attending. So thanks, Adam, for organizing this great seminar. Try to listen to it from time to time, and so kind of the great thing about Zoom. So let me share my screen. Just a second. I hope does it look okay? Is it okay? Or
yeah, it's okay. It's okay.
Oh, okay. Sorry, I couldn't hear it. Yeah. So so this is kind of Adam. I think the instructions to all the presenters was not to talk on your own research, but try kind of to discuss a broader topic, which I try to do. I have to say I couldn't help it. So I do have some discussion of mostly work in progress that I have, which is kind of in line of my larger research program in the lab that I have now, but it's still kind of mostly try to talk about the bigger issues and kind of identified points of connection between law and behavioral public policy. So let me kind of start with it. It's actually, I thought it's 30 minutes, so I'll try to fit with 20. So the legal framework is kind of, add to the discussion things like, how people behave and how they ought to behave, caring about autonomy. We know a lot from behavioral public policy. There's a whole discussion about the fact that, experts like Milkman, I think, has it in some of her mega studies where experts' predictions are not even correlated with what's working. And then the question is, okay, what does it say from a legal perspective? The fact that you offer something, but you can't really know if it's going to work. So there is some discussion about experimental legislation or regulation. We don't have that kind of willingness to accept exploratory, but actually sometimes it is exploratory. The difference between compliance and cooperation. So this is really kind of things I'm focusing on, but mostly in behavioral public policy, you focus on cooperation. Compliance is affected by so many other factors. How do you kind of reconcile those? Recognizing, I'll bring some examples that even if you can show that a certain regulatory tool is working better, you can't really always only rely on behavioral rationale. So again, how to engage in the balancing, how to account into the discussion to various institutional concerns, such as the difference in different cultures, caring about human rights of protected groups, legitimacy, kind of sometimes focusing more on long-term impact rather than whatever works. In many contexts, and I'll give some examples in the presentation, we care not just about whether people cooperate, but how is the kind of the quality of compliance. There are a lot of discussion in law and legal theory about inadvertent effect. In behavioral public policy, it's called crowding out. But again, I will show that sometimes it's kind of a much more complex phenomenon than means not all of them are kind of the same behavioral effect. And the idea that we care about long-term and internalization, so in spillover. So there is something very successful, and we do one experiment in behavioral public policy. It's working. Should we or should we not care about the spillovers effects and externalities to other domains? A whole questions that arise because I think of the effect of kind of behavioral economics, behavioral analysis on law should kind of states even care about, causing people to feel that something is more moral or change their views, or kind of the liberal idea that the basic one is that we care only about behaviors. And again, is it even permissible for states to try to build trust, or you should just behave in a way which will earn you the trust of the public, but you can actually work towards it because it's valid some of the ideas we care about. And again, some of the kind of the areas when you see a lot of the I think the kind of the clashes between the two disciplines related to the notion of institutional concerns, and is it only about optimizing the source, the whole idea of comparative behavior public policy. So again, you have it in law. It's kind of usually completely different legal system in every country, but a lot of the research in behavioral public policy try to allow people to adopt from one country to another, and kind of I have some examples that I was advising Israeli government in various occasions, especially in the COVID context, and I brought some study from Denmark, and kind of the relatively high-ranking public officials say, "What do you mean? But we are not Denmark." I mean, and I never thought about that, to think about, okay, this was very successful working then in COVID, but then how do you deal with that, especially because usually legal scholars, I mean, there is an area of comparative law, of course, but they actually are very much into recognizing the difference. I don't think it's as much developed in behavioral public policy. The normative difference between the instruments. So, okay, something is more optimal, but once you move it from being, a contract, from being a law to a contract, you actually change a lot of things. Mandated versus voluntary, something you see a lot in behavioral public policy, again, coming with a lot of normative baggage. Usually, I think this is the area when you see a lot of kind of the focus of lawyers, but I hope it to change beyond. But this is, again, actually an area where the whole limitation. So there is, the behavioral public policy try to innovate, be very innovative in changing behaviors, and then the limitations is where you look at lawyers. I hope this would kind of change. Personalization, also a big topic, again, with a lot of problems, and I'll mention one project. Not just the negative externalities, but also a lot of times, if you don't trust people in a certain context, it might actually have a lot of positive externalities, which related to the unit of analysis. Just kind of one slide about, what's for people who don't know what lawyers even doing in this seminar. So it's actually a huge a trend within legal scholarship, the whole kind of law and behavioral economics, law and psychology. And when it started, it was mostly about kind of protected groups. So the idea was about insanity. It's a very old concept, the best interest of the child. But when witnesses experience some traumatic events or memory biases, visual biases, predictability about criminals, but I think in general, until something like maybe 30 years ago, really kind of the interaction between psychology, behavioral sciences, and law was very, very limited. I think the big change happened following Tversky and Kahneman kind of research on prospect and framing, the kind of the whole biases literature. And I think the paper that led to the change by Joel Sunstein and Thaler, sorry for the typo there, from '98, where it's kind of created this field of behavioral law and economics. And mostly, if you look at all the kind of the focus since that period was about people are kind of bounded, people are biased, and because of that, the whole legal institutions, the legal scholarships developed around the world should be revisited, because freedom of contracts was seen as a huge advancement, but it's for people who know what they're doing. If people are not as good at thinking about statistics, about risk, about the future, maybe we could limit them and come up with all kind of limitations of how free they are to contract as they wish. And then we really see a proliferation of behavioral studies. I think really the fastest growing kind of area within law, where every doctrine in law now has behavioral perspectives trying to change it. And as I mentioned, I want to talk about the work progress, which is related to the lab that I have now in voluntary compliance with the ERC grant. And some of the things we're trying to do there are related to some of the dilemmas I mentioned, where the idea is to try and combine kind of the behavioral approaches related to cooperation, pro-social, and social norm with research in law about compliance, and try to kind of identify the context in which the different regulatory tools could lead to not just to a change in behavior, but actually a behavior which will be ideally with less sanction and with more focus on intrinsic motivation. And the question is whether it's going to work. So can democratic countries work in a world without sanctions? What do we want to gain? What are we going to lose? And it's kind of focusing on 4 domains, on ethics and COVID or public health in general. Hopefully no more COVID, and taxes and the environment, and then across different segments of the population and across high trust countries and low trust countries. And some of the concepts we're trying to build, and again, it's now a group of close to 20 people, is trying to create this notion of effective voluntary compliance where we can understand not just kind of, again, a change in behavior, but people with greater willingness to pay for it, with higher quality, and engaging even within things that you're not expected to do for a long time. So, and also lead to some process of internalization. And kind of an example, a paradigmatic example is the difference between vaccination and mask wearing, where when you want to encourage vaccination, it's enough if people get the vaccine. If you want people to wear masks, you want them to some extent do it properly over time. So just kind of to show that in certain behaviors, we need more than just the cooperation of people. Moving to another project, which I think demonstrates this difference between how legal scholars and psychology or behavioral public policies, including political scientists or psychologists or economists working in this area, is related to this, again, new approach of big data, helping us know who can we trust. And again, it's kind of, I collaborated here with 2 legal scholars, Ori Aronson and Orly Lobel, where we actually show how complicated it is, and whether we know a lot of things now about people. To what extent the fact that we know something about people does it need to be by some, I don't know, judicial institution said that this fact actually happened, or we can assume it if it's an administrative fact or some other source of information. Has a lot of interesting questions about, for example, cross-domain. So this is something we try experimentally, but normatively, does the fact that someone is really bad in paying taxes, is it okay for us to assume other stuff about his kind of behavioral intention? To what extent, even if it's predictive psychologically, to what extent we actually want to live in a world where such cross-domain predictability happens? And even the kind of the other focus is the group level trust, where this is, I think, a more known, at least in legal scholarships, where we actually really want to make sure that we are not taking all kind of groups that for various reasons suffer from prejudice or kind of a more or weaker in many ways, and by kind of assuming certain things about those groups, we are actually harming them, even though it might help us in the prediction. And again, this is a huge area within law, but it's actually, I think, going to become relevant to so many other domains. And this is just, I was recently in a conference in Florence, and I noticed that in some of I was kind of inspired by the original nudge with the Schiphol airport. So I noticed that in some of the restrooms in Florence, there was the kind of, you had free toilet paper. In a sense, you can take as much as you want. And some is kind of the more common one where you actually can't really take so much. And to some extent, I was kind of wondering to myself, how did they know who to trust, right? So how do you know how much or what approach, and whether there was some data mining, or is it just, I don't know, they're very generous. But again, I think it's the idea that whether you can trust or not, even in really kind of stupid contexts, such as how to present the toilet paper in restrooms, is really affecting everything. And the question is, what can we take into account? So again, there are a lot of questions that will, again, coming from a legal perspective, things that private actors can do, state cannot do. Sometimes being very transparent actually might become very humiliating, so maybe we don't want to do it. What happens, for example, with trade? Some compromises we see in the literature that, let's say, plumbers are more likely to evade or to kind of omit income relative to, I don't know, doctors maybe, and then, it comes with a lot of sociological implications. Can you do it? Can you not? Importance of effect sizes. So again, just to show how complex is if we want to kind of satisfy both the behavioral prediction and the legal domain. And we tried kind of in that paper to focus on what's called proportionality. It's a doctrine in constitutional law in some countries in Europe, also in Israel and Canada, where the idea is that you might be kind of, it was permissible for you to rely on such factors when it's predictive enough, when it can cause you to do a lot of good for the public, and when there are no other means. So there is a famous case in the Israeli airport where the court forced the airport to buy a lot of very expensive machinery to avoid profiling in a way which everyone could be now screened, so you don't need to decide who to screen more. So is it something like that where you can invest more in better machinery might be a solution to a lot of those kind of big data predictions. And then the question is, again, we all know about the pyramid of compliance. Are we getting into a stage where we might be able to treat different people based on whatever factors, with kind of not, having to go into regional responsive regulation where you start with everyone and then kind of change kind of your approach, but actually do it ex ante based on some evidence on past behavior or other predictors. And now I want to move about kind of another project about the notion of pledges. It's a project with Eyal Pe'er also. I'm not sure if he's here, but he comes through a lot of those seminars. So we did a lot of projects. We did it also helping the government deal with a lot of issues of trust in people and try to replace the need to show evidence. And again, I'm not going to get so much into when it works. We have actually a lot of papers showing it working pretty well, working also on brazen liars. But actually, the point I wanted to make is related to a different project, which is related to the pledges, but compare it to affidavits. This is with a postdoc. We had Rinat Markovich, and there was actually an interesting, again, kind of tension between law and psychology, in the sense that almost every dimension we measure, pledges were better. It worked as good. It was not that, liars preferred pledges to affidavit or something related to willingness to or people kind of intention to lie. People preferred it more. It was more effective, but still you have a lot of institutional concerns. And we try to push it with the justice ministries for which we did all those studies. But you have this, idea that we want intermediaries, we want lawyers to kind of be somewhere in the process and make sure, supposedly somehow believe this is helping. So this is, I see this project just as an example for, it doesn't matter if pledges work really nice, to make a change. Again, the experience I have with this is only with Israeli government, but I think it's broader. There are other kind of institutional concerns which might affect what tools are being chosen. This is another project with David Levi-Faur and Libby Maman, where we actually show that preference for trust-based regulation, so kind of softer approaches, depends really much on the trust in regulators. So when it's kind of a command and control, people don't care so much if they trust the regulator or not. But when you kind of want to show whether people are going to trust corporations which are being regulated by things like pledges, then you need high trust in the regulator for this to work. So this is, again, kind of showing when you focus on the whole regulatory, the behavioral kind of sandbox, trying to compare regulatory tools, you need to also account for the level of trust in a given country to know which tool is more likely to gain the public trust. Another, I think, interesting domain to think about is the whole notion I mentioned before about whether kind of using law to enhance social phenomena we think are working well, are these likely to enhance it or to disrupt it, related to the crowding out effect I mentioned before, that I think in some other work I show it's actually sometimes even 9 different processes, but we usually call it kind of one crowding out, but it could be completely different mechanisms related to lack of trust, open justification, attention, reactance, and so on. But it's really more complex phenomena. But again, the question is, how do you treat it? Okay, let's say you treat it from a more legal perspective, usually you will have a broader perspective, how much it's actually harming how the regulator is being viewed by the public if a certain action is not working pretty well. And there are some studies showing that there are negative externalities. So it's not just the effect in the specific occasion. And again, studies I did myself coming up with conflicting prediction. There's one study I did with Tom Tyler showing that mandating procedural justice actually enhance it. And in a different project on the nation law in Israel with Gidron and Barak Oren, we actually showed the reverse. So law actually leading to psychological reactance. So again, a very complex and unpredictable area. This is another project with Slater and Crucelli when we try to kind of show the regulatory instrument dilemma where it works on originally in a prisoner, sorry, no, in a dictator game, not a prisoner dilemma, and kind of compare the level of giving in the first place and then seeing what's the carryover effect after a few minutes where we had kind of a filler. And this is, again, just to demonstrate this approach and idea that, again, not just to have a behavioral public policy that try to change reality, but think about long-term effect. Just kind of a slide from Van Roy work showing how complex is compliance relative to cooperation. And I think I will end maybe in this slide. This is, again, work with Maman and Tom Tyler, where this is a recent work in progress where we try to compare across countries with different level of polarization, the likelihood that trust-based regulation will work. And expectedly, the more polarized country, it's obviously harder to build on trust working, but there is something we did not anticipate to actually showing completely different results for right-wing and left-wing polarization. But again, this is just kind of using it not too much to focus on the paper because obviously I'm not giving enough details, but just to kind of show the broader argument that I think there is a need for a broader kind of perspective of behavioral public policy, taking into account also legal consideration. Again, not just in the notion that I think mostly now it's about the limitations. So people know, okay, if you have some ethical thing, you should go to talk to a legal scholar, but it should be, I think, something which have much broader effects on the design and the understanding of what or how can a state organization change the behavior of people. So I'm gonna, I think, stop here and go to Q&A.
Thanks, Luke. Yuval, that was very interesting. Thanks a lot for that, and you kept well to time as well. So well done. I'm going to throw it open to the floor now. Could you just put your hands up in the usual ways if you want to ask a question while people are thinking about it? I mean, maybe I'm just going to say something dumb here, but is the essence then of legal contributions that just institutions matter? Would you say that's the message, Yuval?
Well, I think it's more than that. Of course, it is related to institution, but I think, and again, some of the things I'm trying to argue that it's a kind of a mindset, which is related to. So again, it depends what you count within institution. But when you want to do something, are you only looking at the what's the time frame? What's the unit of analysis? What things you need to think about when you come up with a certain behavioratory intervention? And I think the legal perspective should not be just, and this is, you see it a lot, that this is unethical or something like that, but also should we care about, when we think about intervention, should we care about broader effect on the population? Should we, let's say, when we want to adopt something from a different country, what are the things we should look for when we try to think whether the fact that it's working in a certain country, how likely it is to work? I think like for legal scholars, they know it, right? No one takes just a case that happened in a different jurisdiction and completely adopt it. But I think psychology, there is this feeling of, being more universal. People are kind of, a lot of the experiments, no one replicated every experiment in every country.
Yeah.
So I think it's related, but I think it's broader. It's kind of where you look, how far you look. Is it, the only thing you care about is what people do? Do you also care about what people think? Do you also care about what will happen the next time they will face, the tax authority, the next time they go to vote? What are kind of the things and I think, and again, I don't want to say something, it's not that legal scholars are all of them wanting more influence and someone is blocking them. I think the sad thing that the majority of them are not interested. So you can be a terrific tax scholar not caring at all about tax. It's not even something most of them, think about, or environment. People focus more on the doctrine rather than if it's actually happening. And I'm kind of saying the same thing also to legal scholars, but also I know kind of, when I kind of talked about my grant and I wanted people to join, at the end of the day, all of the people in my group are psychologists, political scientists, and economists. I mean, I didn't have one single legal scholar who even wanting to join, because it's kind of seen as a empirical project, and why should we care?
Yeah.
So it's not,
Well, we should bring them all in, because it's
Yeah.
much broader than that, isn't it? If you want to ask a question, can I just remind you to put your yellow hand up, because then I can see who's in the queue. Nick, you're next.
Yes, thanks, Adam. So very interesting, Yuval. I have a very narrow, specific question, which is on the pledges versus affidavits. So I just wondered if you could say a bit more about what that meant in practice, because that struck me as quite an intriguing finding.
So what we have, we compared, doing all kind of studies, the effect of affidavits to pledges, and the legal
Yuval, just
policymakers.
for non-lawyers. So that's, to you, that's a massive distinction. But what does that mean?
Oh, the question is whether you actually write, there is like 2-3 lines you need to repeat. This is the pledge where you promise to behave in a certain way, or it's kind of, there is kind of a, a lawyer or someone kind of, usually it's supposed to be a lawyer, kind of where you tell him that you're gonna behave in a certain way, and you promise, and kind of the penalty. So it's more formalistic.
So I suppose I'm thinking there are two factors there which are interesting. So one is the formalistic nature, that it's actually sort of written down and codified, and the other is there's an intermediary who's able to say, yeah, you pledged this and you didn't do it, rather than the other one. The pledge sounds like it's bilateral. Is that essentially right? So I promise to you.
You don't interrupt. No, it's
still public.
I just promise. Yeah. It's just making a promise, making it written. But again, there is no in the affidavit. It's not that the lawyer is following you.
Yeah.
Right. So you promise, and then you go into the whatever is it that you do. But it's not that he's overseeing your behavior. But somehow it's being seen as a more serious thing, and it's kind of interestingly, you could think, for example, in our studies, maybe cheaters would prefer pledges because it sounds kind of much easier. We didn't find that, but again, when we try to make the case to the Justice Ministry, who hired us to make this evaluation, why shouldn't you use more pledges? Somehow it didn't work. Somehow they had really a hard time trusting the public enough to give up on the involvement of lawyers in making sure that people know that there is a lawyer who threatens them, that if they are promised something but don't do it, they might be penalized, and so on.
So part of that is that the process of getting a lawyer involved is just complicated and slows things down, and it's different. That's the idea. Is it's just a massive friction.
Yeah, that's kind of the administrative burden that is being ignored. That because you want more from people, you end up getting. It's not necessarily that you get more honest people, but you get more upset people who might end up just not doing it at all.
Yeah, great. No, thank you. That's very helpful.
Manu?
Hi, Yuval. I'm sorry, my camera is playing up, but I hope you can hear me.
Yeah.
Huge thanks for that. I mean, that was really fascinating. I've done work on commitment devices in the past. It was really nice to hear about all of the honesty pledges. But my question actually relates to something that I've been looking at more recently, which was about compliance, as you put it, or another way we might say that is willingness to accept certain regulatory policies, things at the more stringent end of things as well. So I wondered whether you had looked at that, and in particular, the concept of quality of compliance. How did you go about operationalizing that? And you mentioned at the end there about timeframes as well, because the work that I've done so far and that I've seen being done tends to take a snapshot. But what we don't know is, and it's this I think links to the quality of compliance. If people comply but begrudgingly, do we have enough evidence to know what happens then over time? To what extent is that compliance sustained or threatened? And then with the spillover effects on cohesion, trust, etc.
Right. Yeah, so great questions. About the quality of compliance, so we did two studies. Again, the whole grant is relatively new, so but it's before that we did two studies about the quality. One was people had to agree to edit a document, and then it was under different kind of experimental conditions. And then we had kind of an algorithm that evaluated how well was the editing, and we manipulated, for example, people got certain instructions to what to look in terms of grammatical errors, but then we inserted in the document errors which were not requested. So we kind of was the beyond compliance. So did people did more than they were asked to do, and how well they did what they were asked to do. So the editing assignment we thought was a good way to evaluate quality of compliance, and we actually so this was published in Regulation and Governance a few years ago. I can send you the reference where we showed that as an example for quality of compliance. The other one was we measure was kind of how far away was the recycling bin, so to measure kind of intensity. So if you really believe in it, you will walk 100 meters or 50 meters, or just to kind of vary the how far. Again, this is not a field study. This was intentions. So it's more limited in that regard. The previous one I mentioned was actually incentive compatible, so it was somewhat better. About the longitudinal effect or whether manipulating certain, so we try now to do it. I mentioned, I saw one slide with the paper with Kricheli, where we try to do a series of games and we give instructions in the beginning, but then try to measure the carryover. But this is few minutes, so it's not really. One study in the past I did with Mariam Kochaki, we actually did it over 3 weeks. And every week people came up to the kind of, we logged online and then did it again. And we tried to kind of, and that was kind of the code of ethics effects on honesty over time. So this was in that study, we have some findings there. And also in the paper with Pe'er, again, I can't say it's long but it was like 20 minutes, but we had rounds. So we could evaluate the declining kind of the effect of different instruments. But I think, it's easy to think of other ways. And I think, again, I think again, I don't have the evidence for it, but this is something we really worked hard. I mentioned the example with how to cause people to cover both their nose. And in COVID was the hardest challenge we were given as the experts who were trying to help, is that they had a lot of police officers in Israel trying to give fines, but there's no way for them to fine you for doing the right thing. And this is kind of the challenge there. Yeah, thank you. Anli?
Oh yeah, Annelise. Sorry, I was muted before. Sorry about that, Manu. To introduce you, Annelise. Yeah, you're next. It's very quiet, Annelise. Either you're muted or you need to get really close to your microphone, I think. We can't hear you, Annelise. None of us can hear you. I think you have to shout into your microphone, probably. While Annelise is sorting that out, can we
better
Yeah,
now?
Oh, yeah,
that's
it's much
that's
better.
good. Yeah, that's good.
Okay, sorry about that. This is a follow-up question to what Adam asked. So his question was, well, what's your high-level message, from law to BPP scholars? And my question would be, is your high-level message about BPP to legal scholars and maybe to policymakers? Is it, if you care about the effectiveness of law, if you care about compliance, then you need to look into the insights from BPP? Would that
I would say both, but to some extent, this seminar. So I was thinking about representing the.
Yeah.
I know you're a legal scholar too, but so representing kind of the law perspective to behavioral public policy. To some extent, most of what I do is the other way around, right? So when I talk, I'm in a law school, and I'm a law professor. So most of the time, I'm trying to convince my co-authors, my colleagues that again, now it's easy. I mean, in the early days it was seen as crazy as you're trying to say psychology matter to something. Again, as I say, it was mostly around the insanity defense, not so much about. But again, I think economists opened the way for legal scholars to rely on psychology to some extent, and I think we had in the past some discussion about that, the effect of economics on law. But in general, I think the message here I want to say is that there is a lot of things in law, not just ethical limitations, which are related to behavioral public policy. I think present itself as a field which is very much interested in helping governments and organizations be better in changing the behavior of people. Up until a few years, this was kind of solely what the legal system was about that, right? When we thought people were simpler, so you just had, you had laws, regulation, norms, and then you could sanction. There's command and control, and that was kind of the role of the legal system. I think when we know more about nudges and more instruments and more kind of actors involved, and the regulatory area becomes so much more complex, there is more room now for non-legal scholars, obviously, to work, and they have better empirical abilities. There's a lot of reasons why legal scholars are not leading the way, but I think still there are important concepts that could be drawn from legal scholarship into behavioral public policy to make it an area which can offer more kind of sustainable, just, long-term, broader effects on society beyond kind of the, sometimes I feel is kind of, okay, we increased tax payment in 3% doing that, or something like that.
Oh, I think Paul.
Yes, thank you very much, Yuval. I was trying to understand what you were saying, but you were going quickly over a huge field and many terms, which was sort of new to me. So I was struggling a little bit to sort of get the main insights that you were trying to tell us. So I have a couple of questions about that. One is that, as far as I was able to see, the perspective you take and that this field takes is sort of from power to people, right? So the perspective of how do we get people to comply with what power wants, right? And you just have another phrase like that, which is helping government and organizations influence. So that's my first question. Is this right? That basically you're sort of on the side of power, and you're sort of, you do its bidding, you write reports from ministries and that sort of thing. How do you get the buggers to behave, basically? Now, the second question I had with the sort of methodology that you were describing was the use of lab experiments, right? When I think about laws that pass parliaments, there's so much difference between how it might have been intended once and what comes down, that, it takes years often, it gets reinterpreted, it it enters a battlefield of not just legal scholars, but also corporations who interpret it in different ways and push it. And so to a certain extent, that is miles away from the lab experiment, whereby you can tell somebody, okay, this is what you've got to do, and this is a consequence, and 5 seconds later it happens. That's pretty much miles away from, you know, the whole legal system. The legal system is sort of like a Titanic, moves incredibly slowly, and no one knows where it moves to. But this notion of an actual intent of someone in power to make you do something, who's got some sort of actual sort of punishing ability, no matter what the law is, right, is a very different thing. So almost, for me, a lab is almost a highly non-legal environment, and not clear what you can learn from the lab about law. It's a totally different setup. And so that was sort of my third question. So how do you envisage law in this? Is it actually, look, power can do this to you now, comply, which to me is not the law. The law is this hugely complex thing that no one understands, and that, you know, it's a continuous battleground as people do all kinds of things which are not the law. So those are my 3 questions to sort of get a hang on what you were trying to tell us.
Yeah, great question. So, yeah, I mean, the first question, I mean, the way you phrase it, I don't want to be, you know, helping power to control people on one hand. I think the maybe more optimistic description of what I try to do is that states try to control people anyway. Research like that, and again, it's hundreds of people. It's not, you know, me, but a lot of people are within this area. I mean, even with law, I mean, where the idea is, for example, you know, think about the addition of things like procedural justice, or think of the idea of showing the advantage of trust-based to command and control. Thinking about, you know, the whole kind of non-paternalistic approaches which are being developed. All of the research about the problems of crowding out, which all of them showing you think you could sanction, and you obviously have the legal power to sanction, but it comes with a price, and we want to expose you to the price and maybe convince you not to do it. So actually, if I were to say, I think a lot of the contribution of, you know, behavioral approach to law ended up actually causing legal policymakers to be actually more concerned about their power rather than the other way around. It's true that, and you know, and this is, I thought, something which will not be new to this audience. There is, I've heard it in the you know, the conference that was that Adam taken it, the whole notion of kind of nudges and implicit effects and all that. I think this is being recognized that there are also some evil happening within behavioral public policy. But generally speaking, I think, especially relative to other fields, I think psychology really uncovered some of the problematic effects, negative effects of using power. And most people in this tradition actually tries to advocate to limiting power. So this is answer to the first question. The second one is, again, and this is the most fundamental question in a related area. It's called now, it's kind of sounds stupid for everyone outside law, but there is this field called empirical legal studies. So everyone, you know, I told to my friends that there is like psychologists that the reason say, okay, I'm an empirical psychologist. They kind of, you know, laugh at the concept. But for legal scholars, because most of them traditionally only were interested in telling people how they should behave, not so much how they behave. The notion of empirical was kind of new, and it's, again, something less than 20 years. And this is the question everyone asked. And again, I think if you focus on lab experiments, again, there are other methods as well. It's not the only one, but if you really care about causality and manipulating, I think even lab experiments can help you identify factors. Usually, every government I know about, we want to run some some field study to following a lab research before it implements a law, if it's based on some kind of behavioral recommendation. So I think you're definitely right. And it's actually interesting also because there are certain, I mean, I think, for example, it's easier to manipulate morality in a lab than to manipulate deterrence, right? So even if you see a lot of lab studies comparing morality and deterrence, I always think, you know, you can never mimic the real fear people feel when they have this, you know, tax authority, people coming to look into their books. I mean, just kind of, you know, the penalty of €5 or something in a lab research will never mimic that. But the idea is to trying to understand the factors and compare them. You are definitely right that they're quite limited. About the third question, again, this is an area within law. It's called law and society. You know, the whole idea that you know, the difference between law in the books and law in action, and the idea that law is affecting behavior in so many more ways than just kind of parliament passes a bill and then you know, we see what happens in the public. It goes through a lot of this is really kind of mostly, at least within legal scholarship, this is the work of sociologists, mostly some political scientists, who try to understand kind of the law is a much broader phenomenon. I think it's very common. You see now even kind of regulators, they know to say all of those concepts. They themselves recognize how limited they are in trying to enact or change behavior, and they're very kind of familiar with the idea that there are many other institutions beyond legislation that is representing behind what people call the law. Yeah.
What are the questions? And I've got some. I mean, it's ill-formed in my mind here, but it's just a sort of thought of it when Paul was asking these questions, really. So I'll throw this out there and just see if there's any traction to this, I suppose. And anybody can answer, but this is for you, Yuval, but Paul might want to come in as well. I mean, I'm just asking a series of questions here, I suppose. Is it that, I mean, a lot of law, surely, sort of rules and laws in society, they must have evolved for psychological reasons originally, right? So, you know, like you know, the social norms may have formed around sort of certain sort of psychological expectations or concerns, I suppose. A lot of them to do with trying to hold societies together in some sense, you know, to sort of curtail the passions, if you like, or egoistic interest. And then on top of, you know, over time, you know, laws became more solidified rather than just relying upon social norms. You know, they were more sort of formalized, I suppose, is the term that you used earlier, Yuval.
Mm-hmm.
But in terms of the application, so the motivation may have been psychological a lot of the times, might it? But then the application may take us away from real psychology. It seems to me, I mean, I've only read a little bit around this, and it seems as though the legal profession, to the extent that it does consider human behavior and criminology as well, sort of, you know, an associated field, they still have to rely upon the assumption that people are sort of economically rational, you know, in that sense, you know, rational in the sort of the way that economists think about it. And therefore laws may have been put in place with those assumptions that then have taken the whole field away from actually how people do behave. But there might be, the further thought I had is that there might be reasons for that, might there? That if you rely upon the passions, if you like, in terms of the application of the law, then you might get laws that are very, in the modern world, may be considered to be very uncivilized, right? So, you know, you could still have threat of public beheadings, right? Which will, you know, scare people. So they feed into the passions. Could be quite effective, but may take us beyond the realms of what we now think is kind of civilized practice. Does any of that make sense?
So this is kind of, I think this is beyond the question about behavioral public policy, but in a sense, you try to ask whether the law or legal scholars should even care about the psychology of people, because you're kind of afraid it might lead to, in a sense, if I understand you correctly, you kind of say you almost want legal scholar not to know anything about human behavior, because if they knew too much about human behavior, maybe it kind of it's gonna prevent them from performing their their social functioning as being somewhat related to kind of the blind justice kind of that we don't know anything, we kind of say what's right. And so I think there's definitely a tradition, a lot of tradition in philosophy which will talk about kind of the being removed from passion and focusing only on rationales. I mean, I think that this has to go with the idea of empirical research. So I think if you were having just kind of legal scholar, reading psychology, I can see what you're kind of saying. Okay, this might get us to problematic situations. But I think to the extent that you have kind of the institutional boundaries are kind of clear, but at the end you think, okay, we want people to care about the environment, and there are certain things we want them to do within that. And this is, we make sure that the goals are right and justified by non-psychological rationale, by philosophical or whatever. When we think, this is still within the legitimate things that states are and democratic states are entitled to do. And within that, I'm thinking about how to cause people to feel it's legitimate, how to cause people to maybe gradually change their behavior in a which will be more kind of climate friendly. But I think, I think the things you suggest are, I think, also a question to behavior public policy, because I know this is like Sunstein was getting a lot of heat in the early days, where they say, okay, if you start to deal now with trying to cause people not to drink soda or something, right? You want to affect people's diet. You want to, the more you get into kind of practices, okay, you say, okay, you are entitled to do it because you protect their health. But again, you kind of on a more shaking ground. I mean, I think originally when the idea was kind of the more libertarian thing, okay, we are making sure people are not harming each other. That's our mandate. And there is this argument that because of what's now called behavioral public policy, states allowing themselves to engage in changing behaviors they never thought of doing before. When before, the only thing they can do was saying this is illegal or tax it, they will never think of using it. When you create nudges, the fear was that now you can cause people to climb the stairs. Someone could say, who gives you the legitimacy to cause people to climb this, and this could, so I think in that regard, I would say that it's to some extent, one could ask the same question for behavioral public policy, who make sure there that they're not trying to promote goals.
Absolutely. I get you. Does anybody want to come in and have the last question today? Okay, so I'm just going to ask you one last thing then to finish off, Yuval. This is a hard question. I've got to do a lecture on criminology and behavioral public policy, and I know criminology is not it's just an aspect of the law, I suppose, isn't it? And I know nothing about criminology, well, very minimal. So I'm just gonna, I'm kind of winging it really. I'm going to provide them with a smorgasbord of potentially relevant issues to criminology. What would you say? And you can come in, Annelies, as well as you said. What would you say would be the number one thing to try to get across to the students regarding the law and behavioral public policy? Maybe I'll ask Annelies as well for both of you to give a response there, if you can come up with one.
So just to clarify, it's criminology or criminal law?
It's going to be criminology, actually, but I can bring criminal law into it. I can sort of relate it across.
I think, this is the most thing that people want to know is whether criminal law is a good tool to change the behavior of society. So whether if certain behaviors we really don't want people to do, whether criminalizing them, that's the right tool. And I think here behavioral research show how complex is it. I think the intuitive perspective that was, in power 20, 30 years ago was that, okay, if you want something not, that people not to do, I don't know, there was something about things related to usage of marijuana or things related to prostitution or certain things. The idea was criminalizing it is the solution. I think the research, and again, it's not just psychological research, but some other research show how complex is the effect of criminalizing acts. You have forbidden fruit effect, where actually you make it actually something which it becomes more attractive rather than less. You have all the limitations of sanctions that are not targeted at the right people. You have the problem with the enforcers, which not necessarily know what was the original intention and might create their own world out of the authorities they are given. I think, to me, the kind of the notion of whether criminalizing is actually still the right tool to use would
great.
be the first one. But maybe Anli has a.
And Anli, have you got like 1 minute or 30 seconds?
Sure. I think, first of all, in law schools, criminology is seen as a distinct discipline from law. And if you speak to criminologists, you maybe want to tell them what Yuval just discussed. I think I agree, this is a really important point. But you may also want to tell them about behavior irrespective from the law, because their focus is to understand behavior, to understand criminal behavior, to understand rehabilitation and what works, quite apart from legal tools. So I think there's maybe a more direct connection between behavioral insights and the focus of criminologists that doesn't need to go via the law.
Great, thank you both. Thank you for helping me write my lecture. We need to finish today. It's 2:00. We're on the hour. So I just want to thank you all for attending, and the questions again are great as ever. And of course, thank you so much, Yuval, for taking the time to do this. It's great to have you contribute today.